10 minutes.
I really don't think, I think 10 minutes would do it all together.
Okay.
But I don't want to give myself too much because I might take it.
I understand. You don't have to, you don't have to use all 20 minutes, so you take as little time or as much time as you need.
Thank you, and good afternoon to you all. Mark Chapman is my name. I'm here with the Nashville Bar. I represent the appellant Martinez Carter. Here in this probation revocation matter, the question is whether the trial court erred in upholding the appellant's probation violation. And what I noticed about this case at the hearing itself was that the detective had, like a lot of detectives, come into the court somewhat cold. These are busy people, these types of cases, dime a dozen. But he testified that he had not viewed the video and audio feed in a long time, quite some time. And the same thing with the pictures, rather the same thing with the file he said he hadn't viewed in quite some time, but he did say that he had not long downloaded or taken a screenshot of some of the feed, which he presented to the judge as evidence. And this was problematic for me, sitting there listening to Detective Ray's testimony, and especially when it came to the district attorney Boudreaux, who, when I made my objection to the photographs that the detective purported were from the actual video feed, I objected because he said he hadn't looked at the photos in quite some time, so how did he download them earlier that day? And later, General Boudreaux corrected the detective and said that the photos that he had been testifying about had not been pulled from the CI's video feed, but rather were from the case file. And so you may say, well, why does that matter? Well, the man said where he said he got the pictures from, and the DA, which was interesting, that a DA would contradict his officer, and the DA was very forthcoming.
Well, so assume the pictures should not have been admitted. Assume that was a problem, because whatever argument you want to make as to why they shouldn't have been admitted, you still have the testimony of the officer about how he, they made the phone calls, your clients overheard on the phone agreeing to the drug deals. They checked the CI in his car to make sure he didn't have drugs or money. They watched the CI. The CI comes back. He all of a sudden now has drugs and money. Has drugs, no more money. We're just talking about a violation here. We're not talking about a conviction beyond a reasonable doubt. We're just talking about a violation. So even if we throw the pictures out, does it matter?
Well, let's throw them out.
Okay.
And assume arguendo. Here's an officer who admittedly has come in cold and has said such, and so we're relying almost entirely on his recall. And what a CI told him, and this is a very questionable CI, a CI that appears, now you see me, now you don't CI, and you're supposed to, the police is supposed to be following this individual, and the they're lost for an amount of time, then they come back, and it's very convenient for the CI, as we argued here on page 9 of our brief, that Detective Ray lost sight of this confidential informant for some time, and then later were able to pick the confidential informant up and follow them again. And we argue that any clever informant, including this CI, had ample opportunity to have left other contraband for Detective Ray's team to discover.
Well,
now,
but-
you
but-
argue,
but-
why would they in the world would
But
they?
what you're making is really a credibility argument to the judge, to the trial judge at the time, if you made those arguments. And the trial judge looked at the police officer, heard his testimony, weighed this all and made a determination. We don't make credibility determinations. The trial judge did. And he found that there's a violation here.
And that's correct. There's a violation here based on an officer who comes in cold, hadn't seen his file in a while, hadn't viewed this information, and he's going with this suspect CI, and you say, well, assume all that. That's the accreditation that the judge made.
How do we reverse that if we don't make credibility determinations?
Well, that's a telling question, and you can tell how I move on to my next issue. That we argue. We argue that here the trial court erred in its consideration of the testimonial proof based on this reappearing, disappearing confidential informant, and as the court has already found, it's not altogether helpful to the appellant. But the fact that the DA has to put a stop to this testimony train because it's not rolling properly on the right track should have been a cue to anyone who wanted to know what was actually going on, that it's not exactly as stated. And so at some point, the truth got to be worth something. Now, we will rely on our brief as it relates to the third issue about the length of sentence and such, other than to say the court very well could have accredited, or should I say deducted the amount of time that Mr. Martinez Carter was on probation and he was not doing anything that was in any violation. But the court didn't see fit to do that. And so unless you have any other mortar, I'm going to sit down.
Thank you, Counselor.
Good afternoon, Your Honors, and may it please the court. Ronald Coleman on behalf of the state, filling in for Caroline Weldon. This court should affirm the revocation of probation because the trial court properly exercised its discretion, one, in finding that a violation occurred, and two, in determining that the appropriate consequence for that violation was full revocation. First and foremost, I would like to sort of set the record straight and clear up what exactly happened. The defendant stated in his briefing today that the officer relied on the CI and that the CI sort of vanished and they lost sight of him, and that could have been sort of room for something suspicious to happen. What Detective Ray said was they had a confidential informant for these two separate buys, and what they had hooked this informant up with both audio and visual equipment, so that at all times they heard what was going on and they could see through the video. The losing side, Detective Ray said that at some point they drove off and we couldn't see the confidential informant or the defendant with our eyes. But at all times they had a feed to that audio and to that visual. So I think that that's important to put that into context. And so here the trial court properly exercised its discretion in revoking probation because when it properly found that a violation had occurred. To provide some factual context, in 2010, the defendant pleaded guilty to several drug offenses and got consecutive 8-year sentences of probation. While serving his first probation, that he committed a violation, and the trial judge, in sort of a form of largesse, only revoked the first probation. Once the defendant got out, he began serving his second 8-year probationary term, and relatively shortly after he had gotten out of jail, he was involved in 2 sales. So Detective Ray stated that they had a confidential informant, and on 2 separate occasions, they observed this informant call the defendant. They heard the defendant's voice over this telephone. They then equipped the confidential informant with audio and visual equipment, searched him, made sure there was no large amounts of money or anything suspicious, gave him a set amount of money. The confidential informant went and met with the defendant twice, left with money and no heroin, came back with heroin and no money, and said that there had been a sale. The trial court accredited Detective Ray's testimony that this happened and found a violation. To briefly touch on these photographs, screenshots, there's really no question as to what they are. I think below the defendant's objection was very unclear, and on appeal it seems that he's trying to make a hearsay or a reliable hearsay argument. What's really at issue is whether these were properly authenticated, and whether the detective took the screenshot from the video or they were screenshots from the file. None of that matters, because when Detective Ray looked at these photographs, he said, I was there, I watched the confidential informant, I was seeing this video, these are fair and accurate representations of what happened on those 2 sales. So it was properly authenticated and the court properly admitted it. But even if this court wants to go to your point, Judge Dyer, if we want to throw that away, we have accredited testimony of the detective who observed and saw these 2 drug sales. That alone is sufficient to establish a violation. So trial court properly exercised its discretion. I'll briefly touch on the consequence imposed and this sort of street credit claim. The trial court made the relevant considerations when determining what the appropriate consequence was, and laid its reasoning out. And so this court should find that was a proper exercise of discretion. And then lastly, with this street credit claim, that was presented to the trial court, and he found that the defendant had not established any reason for why he should get the street credit.
Where in the statute does it say that the defendant has to prove he's entitled to street credit?
So there's not a burden on the defendant specifically, but the trial court...
The trial court statement seems to make it sound like you have a burden to prove to me you're entitled to street credit, does it not?
It's not the most eloquently worded, certainly, Your Honor, but ultimately what the trial court, when he's going through this, finds that the defendant is entitled to credit for time that he served on a concurrent sentence, but ultimately he's not entitled to any street credit. And so the court, I think, was saying, viewing these facts, seeing how these things...
But what the trial court said is you haven't shown me why you're entitled to it.
And I think that reading between the lines, what the court is saying is, I can make a discretion either way. Based on how egregious these facts are, my inclination, when I'm exercising my discretion with everything as it currently is, I don't think you're entitled to it, and you haven't changed my mind. So he's not initially putting the burden on the defendant. What he's saying is, I can go either way. It's my discretion based on the statute.
I'm reading a lot into 5 words, or you're reading a lot into 5 words.
You know, and I think that's it'd be great if trial courts could be more eloquent.
I want to talk about street credit though for a second, just in general.
Certainly.
I seem to have had probably 4 or 5 of these here recently where the defendant's claiming he's not getting entitled to street credit. And the trial court's comments in here are what sparked that question. Is it mandatory for the trial court to consider street credit, or does the defendant have to ask for it?
I don't currently. My understanding of the statute, and I haven't done a deep dive into this, but my understanding of the statute is I believe the court can consider. I don't. If you have the statute.
No, yeah, I do. I want to hear your answer, though. Seriously, I'm not, this isn't a gotcha. I want to hear what you have to say.
I believe that it is, that the court is authorized to do it. I don't know if it has become a mandatory portion of a revocation proceeding. Again, I don't have the language of the statute in front of me, but that's just working from my memory. I think once the defendant asks for it, it's something that the trial court should consider. But they can give their reasons and just say, based on the egregiousness or just looking at this, I don't find that you are entitled to it. It's wholly discretionary to the trial court.
Yeah, I don't read it as you're entitled to it, but I think if it's part of something, it's a sentencing issue, correct? And if it's part of a sentencing issue, I mean, a trial judge you don't have to necessarily ask for enhancement and mitigating factors, correct?
Correct.
But the trial court has to consider all enhancement and mitigating factors.
Certainly, but that's on the initial sentencing.
I understand, but here it just says the trial judge may order the original judgment to be served in full, goes on, and then it says it may give street credit. It's in the statute, doesn't it at least suggest that the trial court has to consider it? You don't have to give it, but you have to consider it.
I think
You don't have to give mitigation, but don't you at least have to consider mitigation factors?
I think that's certainly a murky question at the moment, given the language of the statute. And unfortunately, it's something that this court doesn't need to get to in this case because the court did explicitly consider it here. It was presented, whether the defendant initiated that question or not, the court
But
did
did the
consider.
court consider it if the court said, you haven't given me any reason to consider it, basically?
Well, it's not any reason to consider. The court considered it. They had a discussion on it. It was, you haven't shown me any reason to change my mind. I don't think you're entitled to it. You haven't changed my mind, so I'm not going to give it to you.
You've done a great job of avoiding where I'm trying to go, so I appreciate it.
Thank you, Your Honor. But for all these reasons, the court properly found a violation, properly found that the full revocation was the appropriate consequence, and we submit properly found that the defendant was not entitled to street credit. So we ask this court to affirm the revocation of probation. Thank you.
Thank you, General. Do you want to use any of your rebuttal time?
Nothing further.
Thank you. Anything further this afternoon?
No, Your Honor.
We will stand adjourned.